plaintiff's subject matter jurisdiction brief submitted and filed in accordance with court order document/docket number 31 issued on 3/8/2022. Attention Judge JP Stadtmueller and the Clerk of Court for the United States District Court for the Eastern District of Wisconsin. I, pro se plaintiff in this legal matter, am filing this subject matter jurisdiction brief in accordance with document/docket number 31, a court order issued, dated, and filed on March 8, 2022. Judge JP Stadtmueller, the following cited sources and the legal information obtained from the cited sources will not only prove proper subject matter jurisdiction belongs to the United States District Court for the Eastern District of Wisconsin, but will also prove proper jurisdiction and venue also belongs to the United States District Court for the Eastern District of Wisconsin. According to source A, the district courts shall have original jurisdiction of all civil actions where the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and costs, and is between citizens of different states. According to source, the subject matter jurisdiction of a court may be determined by the monetary value of the dispute, the dollar amount in controversy. Small claims courts, also known as conciliation courts, are limited by state statutes to small amounts of money in controversy, ranging from $1,000 to $5,000, depending upon the state. Therefore, if a plaintiff sues a defendant in small claims court for $50,000, the court will reject the lawsuit because it lacks subject matter jurisdiction based on the amount in controversy. The amount in controversy limitations are designed to regulate the flow of litigation in the various courts of the state, ensuring that complicated disputes over large sums of money will be heard in courts that have the time and resources to hear such cases. Also, according to source, federal courts also have diversity jurisdiction, which gives the courts authority to hear cases involving disputes among citizens of different states. If, however, the amount in controversy is less than $10,000, federal question and diversity jurisdiction will not apply, and the case must be brought in state court. Even if the $10,000 amount is satisfied, a plaintiff may start the lawsuit in state court. A defendant, however, may seek to have the case moved to the federal court in that state by filing a transfer request called a removal action. According to source, small claims court may only be used for certain types of cases. The most common types of small claims cases are claims for money, civil actions where the amount claimed is $10,000 or less if the actions or proceedings are for money judgments only, tort/personal injury actions where the amount claimed is $5,000 or less. According to the cited sources above, in relation to 28 United States Code 1332, unequivocally proves proper subject matter jurisdiction, seeing as the correct jurisdiction and venue belongs to the United States District Court for the Eastern District of Wisconsin, based on the dollar amount in controversy in relation to the wording under 28 United States Code 1332. This makes whatever subject matter is contained in the plaintiff's lawsuit or any lawsuit relevant due to proper jurisdiction and venue, which in turn automatically ensures proper subject matter jurisdiction based on the amount in controversy and diversity of citizenship, and also due to the limited maximum monetary amounts of $5,000 to $10,000 that can be sued for in Wisconsin small claims courts. The plaintiff's lawsuit would be immediately dismissed if filed in state court for improper subject matter jurisdiction, which state courts will not rule on based on the amount in controversy, giving way for the United States District Court for the Eastern District of Wisconsin to decide this legal matter, thus also making the United States District Court for the Eastern District of Wisconsin the proper court for jurisdiction and venue and subject matter jurisdiction. Also, the stated information via 28 United States Code 1332 and the cited legal sources undoubtedly determine the requirements under which the plaintiff is correctly suing the defendants in federal court in the United States District Court for the Eastern District of Wisconsin. The United States District Court for the Eastern District of Wisconsin has proper subject matter jurisdiction and also proper jurisdiction and venue over the pro se plaintiff's current lawsuit versus the defendants Alphabet Incorporated, Google LLC, and YouTube LLC. I am also going to take this opportunity to address docket number 31, page 6, paragraph 3, which reads, only statement of damages is a request for $25 million in punitive damages. Docket number 19 at 5, where both actual and punitive damages are recoverable under a complaint, each must be considered to the extent claimed in determining the jurisdictional amount. There is in no way the plaintiff in this legal matter will be able to prove actual damages, also known as approximate damages. Only the defendants, Google LLC and YouTube LLC, can provide information regarding the actual amount in ad revenue stolen from the plaintiff, while the defendants continue to breach their contract with the plaintiff day in and day out, week in and week out, month in and month out, year in and year out, finally culminating with the complete demonetization of the plaintiff's YouTube channel, and to date currently remains demonetized. Docket number 31, page 6, paragraph 3, lines 6 through 9 reads, thus, where punitive damages are relied upon to satisfy the amount in controversy requirement, the court must first determine whether punitive damages are recoverable under state law. According to source 895.043 punitive damages 3 standard of conduct, the plaintiff may receive punitive damages if evidence is submitted showing that the defendant acted maliciously toward the plaintiff or in an intentional disregard of the rights of the plaintiff. Source: punitive damages have been available under Wisconsin law since 1854. Today, punitive damages are authorized by a specific statute, 895.043 Wisconsin Statutes. Under this statute, punitive damages may be awarded if evidence is submitted showing that the defendant acted maliciously toward the plaintiff or in intentional disregard of the rights of the plaintiff. In docket number 28, the plaintiff's reply brief in opposition to the defendant's motion to dismiss for failure to state a claim, pages 1 and 2 of Memorandum Part A, I cited 2 legal sources regarding punitive damages, which are of importance and will also be provided below as an excerpt to this document. B, with regard to punitive damages being a viable awardable claim, according to source, punitive damages Exemplary damages is intended to punish the breaching actors and to deter them from committing future breaches. Punitive damages are awarded not to compensate a plaintiff for injury or loss suffered, but to penalize a defendant for particularly egregious wrongful conduct. At common law, punitive damages can be awarded in any civil suit in which the plaintiff proves that the defendant's conduct was malicious, oppressive, and high-handed, such that it offends the court's sense of decency. 2. According to source, no cap on punitive damages if the plaintiff establishes by clear and convincing evidence that the defendant acted with specific intent to injure the plaintiff. A. With a large substantial amount of digital evidence submitted to the clerk of court and provided to the defendants, any logically thinking jury will quickly view and determine the defendant's actions against the plaintiff were egregious, malicious, very oppressive, and high-handed, as the defendants continuously engaged in wrongful conduct to intentionally harm the plaintiff's ability to earn ad revenue using the defendant's platform. Lastly, Judge Stadtmueller, please pay particular attention to B, in which the plaintiff proves, and 2, if the plaintiff establishes by clear and convincing evidence. And remember one fact of importance, which is the plaintiff in this legal matter demanded a jury trial and rejects your particularly one-sided assessment via docket number 31 of the evidence provided by the plaintiff due to never requesting my complaint be decided outside of a jury. See attachments numbers 1, 2, and 3. Footnote addressing why plaintiff believes defendants cited the Communications Decency Act and the First Amendment in their briefing and more. The plaintiff in this legal matter filed under 28 United States Code 1332 due to diversity in citizenship and the amount in controversy being over $75,000. See attachments numbers 4, 5, and 6. Despite this, the plaintiff's lawsuit was incorrectly filed under 28 United States Code 1331. See attachment number 7. I first noticed this issue upon registering for a Pacer account and now feel this is a particular time of importance to address this issue and question why the plaintiff's lawsuit was incorrectly filed under 28 United States Code 1331 for violation of federal law, which also may have subsequently led the defendants to argue federal statutes in their motion briefing, docket number 25, dated 12/8/2021. Also, Judge JP Stadtmueller, due to the fact that you brought up the issue of subject matter jurisdiction via docket number 31, not the defendants, and certainly not I, the plaintiff in this legal matter, the plaintiff's filed brief for subject matter jurisdiction is solely directed toward you, Judge Stadtmueller, and not only successfully argues and proves proper subject matter jurisdiction, but also argues and proves correct jurisdiction and venue based on local, state, and federal statutes. Addressing the defendant's subject matter jurisdiction brief is utterly redundant due to you, Judge Stadtmueller, bringing the issue to the forefront. I'm going to now read 2 excerpts from Court Order Document 31, one of the most disgusting and perceivably extremely biased documents I have ever read. Moving defendants did not consider subject matter jurisdiction in their briefing. Their briefing instead focuses on federal law defenses, such as the Communications Decency Act and the First Amendment, Docket number 26. It is paramount, however, that a federal court ensure it has jurisdiction before it reaches the merits of a case that is better brought in state court. Plaintiff may be able to pursue punitive damages on his state law claims. Such punitive damages may also be able to exceed $75,000. 5. Conclusion. The parties are ordered to brief the court on subject matter jurisdiction as set forth in the schedule below. If the court ultimately finds that it has subject matter over this case, it will revisit the pending motion to dismiss, docket number 25. Issue number 1 I have is with the judge pointing out an alleged failure by the defendants and appears to be giving the defendants and a legally licensed corporate law firm a helping hand against a pro se plaintiff. Issue number 2 I have is with the wording used by the judge claiming the plaintiff may be able to pursue punitive damages on his state law claims. Punitive damages may also be able to exceed $75,000. Absolutely false on both accounts. There is no way I would be able to pursue my lawsuit in state court due to the amount sought in punitive damages and diversity in citizenship of all parties. Issue number 3 I have is with the judge stating that if subject matter jurisdiction lies with the district court, it will revisit the defendant's pending motion. This from a judge who to date has never addressed any of my motions, including my motion to proceed without paying the filing fee, which went unanswered for 271 days. Issue number 4 I have is, let's say the court finds it has jurisdiction over the plaintiff's lawsuit, which it does, and let's also say the defendant's motion to dismiss for failure to state a claim upon which relief can be granted fails, which it should. Is the judge going to allow the defendants to continue to file motion after motion in what appears to be diversion attempts and stall tactics before either dismissing my lawsuit or granting my demand for a jury trial? The judge has to have figured out by now that I fully intend to and will file an immediate appeal if my lawsuit is dismissed on the grounds of the defendant's meritless motion. Here are the attachments I filed with my subject matter jurisdiction brief, reminding the judge that I definitely filed under 28 United States Code 1332 and demanded a jury trial in the original filed lawsuit and the 2 subsequently filed amended complaints.